Hello Law Matrix viewers. In this tutorial, we're summarizing the case of USS Graphics Pti Ltd. And others versus Urban Print Factory Pti Ltd. And others. This case revolves around a dispute in the printing industry concerning the ownership and return of various items held by the respondents, Urban Print Factory, Pty, Ltd. And others, to the applicants, USS Graphics, Pty, Ltd. And others. Key items in dispute. The main items at the center of this legal battle are a 1998 Mitsubishi 6F5 SPC 5-color offset lithographic printing machine, the Mitsubishi, a Kaiser ASK 8.0 bar SCB compressor, the compressor, an Iveco delivery vehicle, the Iveco, a TCM forklift vehicle, the forklift. Undisputed items. The respondents did not oppose the return of the Iveco and the forklift to the relevant applicant. Frantic visual communication, Pti Ltd. Frantic. The only contention regarding these items was an allegation that the Iveco was in the possession of a third party exercising a lien over it. However, the court found that this lien should not prevent an order for its return. The core dispute, Mitsubishi and compressor. The primary focus of the dispute is the Mitsubishi printing machine, and, by extension, the compressor, as they operate together. Applicants claim to ownership. USS Graphics Pti Ltd. USS asserts ownership of the Mitsubishi. Omega Art 2000 Pty Ltd. Omega asserts ownership of the compressor. Mr. Berger, the sole director of the applicants, stated that Omega initially entered into a written sale agreement with holdings to purchase the Mitsubishi in December 2015 for 4.8 million rand. When ABSA did not consider Omega's credit history suitable, USS stepped in as the purchaser and paid the monthly installments to ABSA, which financed the acquisition. A letter from ABSA dated March 16, 2019, confirmed that the account for the Mitsubishi had been paid in full and authorized licensing authorities to register USS as the title holder. On this basis, USS claims ownership. Respondents' defense, accession. The respondents, including Urban Print Factory, Pty Ltd. Urban, and Spikerman Investment Holdings, Pty Ltd. Holdings, contend that the Mitsubishi and compressor have acceded to the immovable property owned by Holdings where they are situated. They argue that through accession, Holdings has become the owner of both machines. They also denied that USS was the owner and questioned the alleged sale agreement, stating it came to naught and was incompetent in law. Legal principles applied. Rei Vindicatio. The applicant's cause of action is the Rei Vindicatio, which allows an owner to recover property from someone possessing it without consent. To succeed, the owner must prove ownership of the property. The property is in the possession of the respondent. The property is still in existence and clearly identifiable. In this case, the latter two requirements were not in dispute. The core issue was ownership. Accession. The principle of superficies solo sedet applies, meaning that a structure permanently attached to land accedes to it, making the landowner the owner of the structure. For movables, the question is whether they have lost their independent identity and become an integral part of the immovable property. Three factors are relevant to accession: the nature of the thing, the manner of its attachment, the intention of the owner of the movable at the time of annexation. The intention is often considered the most important factor, especially when the first two are equivocal. Court's findings. Ownership of Mitsubishi. The court found that USS had established its ownership of the Mitsubishi. The respondent's denial of ownership was deemed a bare denial and did not constitute a real, genuine, and bona fide dispute of fact because they failed to address the involvement of ABSA and the letter confirming full payment and USS as title holder. Accession defense fails. The court concluded that the respondent's defense of accession must fail. Nature and attachment. While the Mitsubishi is a large, 98 tons, and heavy machine requiring building alterations for installation and removal, experts in the printing industry consider such machines not to be permanent fixtures, and their movement is standard procedure. Even the respondent's expert concluded the machine was intrinsic to the business, not the building. Intention. Holdings, through Mr. Spiker, did not provide any evidence of an intention to permanently affix the machine. The fact that Holdings entered into a sale agreement for the Mitsubishi with Omega, and subsequently USS, indicated that it was not intended to be permanently affixed to the building, as it was sold as a separate item. Lease agreement. The court also dismissed the argument that a clause in the lease agreement between Holdings and Print Shop Denver, Pty Ltd., reserved ownership of the Mitsubishi for Holdings. Even if the clause applied to improvements made by the lessor, Holdings was still free to sell the Mitsubishi and divest itself of ownership after the lease was signed. Conclusion and order. The court concluded that the respondent's defense of accession failed and that USS had established ownership of the Mitsubishi. The court also noted that USS had paid over 4 million rand for the Mitsubishi, and Urban had continued to use it for financial gain since 2017. USS had also tendered the reasonable costs of removal and restoration of the premises. The court ordered the respondents to deliver all the disputed items, including the Mitsubishi, compressor, Iveco, and forklift, to the applicants. Specific instructions were given for the collection of the Iveco and forklift, and for allowing USS access to the premises to remove the Mitsubishi and compressor in the least disruptive manner, with USS being liable for restoration costs. The respondents were also ordered to pay the applicants' costs of the application. That's the summary of this case. I hope it brings clarity. If this tutorial was helpful, please support the channel by liking this video and subscribing to Law Matrix for more summaries tailored for UNISA students. Let me know your next case request in the comments. See you in the next video.